The penalties for reckless driving depend on whether or not you have been convicted of a major traffic offence within the previous 5 years. A major traffic offence is one that you received a court attendance notice for and had to go to court for, such as drink driving, driving while suspended or disqualified, dangerous driving and so on. If it's your first major traffic offence, then the automatic period of disqualification is 3 years. However, the magistrate may reduce this down to a minimum of 12 months if there are good reasons to do so. For example, if you have a good driving record and a strong need for a licence. The maximum fine is $2,200 and there is also a maximum prison sentence of 9 months. If it's your second or subsequent major traffic offence within 5 years, then the automatic period of disqualification goes up to 5 years. However, the magistrate may reduce that down to a minimum of 2 years, again, if there are good reasons to do so. The maximum fine goes up to $3,300 and the maximum prison sentence goes up to 12 months. In either case, the magistrate can, however, deal with you by way of what's called a Section 10. And this means that you get no fine, no disqualification or no conviction, and a good traffic lawyer will be able to push to get you the minimum sentence, including Section 10 where appropriate. If it's your third or more major traffic offence within the previous 5 years, then the Roads and Maritime Services will declare you what's known as a habitual traffic offender, and they will add an extra 5 years disqualification on top of the court-imposed disqualification period. When considering the appropriate penalty in any particular case, the court will look at a range of circumstances, including the nature of the act itself. Was it just the result of momentary inattention, or was it a deliberate or intentional act? It will also consider the degree of danger posed to the public by the act. It will consider your driving history, your character, including whether you have any criminal record, and if so, the nature of that record. It will consider whether you have undertaken a traffic offender program, and whether you pleaded guilty or were found guilty after a defended hearing. If you do wish to plead guilty, a good lawyer may be able to get the charge downgraded to negligent driving not occasioning GBH, or to speeding by over 45 kilometres an hour if you're going very fast. These are far less serious charges. In fact, for negligent driving, there is no mandatory disqualification period. That means the magistrate does not have to take you off the road. If it's your third or more major traffic offence, a good lawyer may be able to get the habitual offender declaration against you quashed, and they will be able to fight for the lowest possible penalty, including, where appropriate, convincing the magistrate to award you what's called a Section 10, and if your lawyer can achieve that, it will mean that you'll have no conviction, no fine, and no disqualification at all.